for this very important topic. We know that the community has some concerns about what's going on in this community. And we understand that it was important for us to set up a forum as a community to have this dialogue. So we have some important people on this panel that I've been working with for some years. And I believe that today we can start this dialogue. This will not be the end all. There won't be all the solutions that take place tonight. But this can start the process for us to start to heal, to have better understanding and clarity on the injunction, find out what are the provisions that's been removed, how folks can get removed off of the injunction, and how we can build a better community to make sure that we're moving as one. So what I'd like to do at this point is have each panelist introduce themselves shortly, and then we'll get started with some questions to start this process off. Tommy Walker, Venice Neighborhood Council.
I don't think I'm not hearing that. Can everyone hear me? Okay, I have a very, very loud voice. I'm Captain O'Murphy. I'm the Area Training Officer at Pacific. I've been at Pacific for coming up on 2 years now. And some of you have had the pleasure of meeting, and some of you I haven't. But what I want to make clear to you is that I'm committed to hearing what you have to say, and I'm committed to striking a balance. There's a lot of things tonight we may not agree on, and that's okay. It's not right, wrong, it's the situation. But please allow me, with some of your concerns, to process them and address them. We won't come to a resolution on everything tonight, but I wouldn't be here if it wasn't important to me. I wouldn't have my team here, Lieutenant Creed, our neighborhood prosecutor, your senior lead. If it wasn't important to us to hear what you have to say, to start working better together, we wouldn't be here in this position, allowing this opportunity to come forward. So just be patient with us as we work through some of the concerns. And again, like Stan said, or like Melvin said, this won't be the last opportunity for you to have a voice in the community.
Good evening, everyone. My name is Arturo Martinez. I'm with the Los Angeles City Attorney's Office, and I supervise City Attorney Mike Fear's anti-gang section.
Hello, everyone. My name is Josh Green. I'm an attorney with the Urban Peace Institute, and my work primarily has been working with individuals and communities impacted by gang injunctions, and specifically representing and working with individuals who want to remove themselves from injunction enforcement.
Hi everyone, my name is Catherine Wagner. I'm an attorney with the H.E.L.P.E.R of Southern California, and not exactly like Josh, but similar to Josh, I've been working on gang injunctions in LA and Orange County.
Thank you, panelists. So here's what we're here to do tonight. Before we start, I'm going to take us back about 18 years. When Venice 2000 first started, this is how we started. Whenever we heard issues and complaints coming from our people, we organized, we mobilized, we had conversations, and we addressed it. When we got the phone calls a couple of weeks ago from some of our loved ones about the gang injunction, we immediately went to work. Because what we was told was troubling. It bothered my spirit, it bothered Melvin's spirit, it bothered our board member's spirit, and we said, you know what, we gotta have a conversation about it. So tonight, this is the opportunity for those who have been served, for those who is no longer in that lifestyle, that feel that they're being profiled, to go ahead and begin the dialogue with respect. Ultimately, what our goal is as an agency is to identify brothers that's on this injunction and get them off, period. And do away with the injunction altogether at some point. So although Anthony Blockman, who's one of our new board members who we started on about a year and 4 months ago, we hooked him up with Josh. And the good news is 2 days ago, Anthony Blockman is no longer on the gang injunction.
Good.
So let's get them for that. Now that happened, it gives us an opportunity to go through a process to determine who all is going to be taken off this injunction. So after tonight, we want to have a follow-up meeting only with our attorneys and those that's going through the process to get off. And we hope that it don't take as long as it took Anthony to get off, and it probably won't, because he's the first, Josh, if I'm not mistaken.
Of my group, he's not the first in the city.
Okay, the first in Venice. So, with that being said, we're gonna go.
Not even the first in Venice.
Not even the first in Venice?
First in a while in Venice.
Okay. So, with that being said, let's go ahead and hear from the audience. If you have a comment, keep it at 2 minutes. If you have a question, direct it toward the panelists, and let's see if we can go ahead and get this done within an hour and a half.
Before we get to the audience, we want to set a tone. We have some questions that we want to ask Arturo and we want to ask Josh about the gang injunction. We want to get some clarity on it. So Arturo, can you tell us the provisions that were removed from the gang injunction so people have some clarity on that? We were told there were a couple of provisions removed. Can you answer that?
Certainly. So first and foremost, injunctions in California are constitutional. There have been some changes in the case law. As a result of the changes in the case law, there are several provisions that are no longer enforceable by virtue of the way they are written in those injunctions. So let's talk about the first provision. Okay, the curfew provision in many of our injunctions is no longer enforceable because of the manner in which it is written. And because of that, the city has taken the position that we're no longer enforcing the curfew provision in any of our injunctions. And as part of that, there were 2 notifications that went out with regards to that particular provision. There was one specific to the curfew provision, and we did postings in the community, mailings to the individuals that L.A.P.E. had identified as having been served, and there was also publications in newspapers of wide distribution in English and Spanish. Subsequent to that, because there have been other changes in the law, within our injunctions we have stay away from narcotics and stay away from alcohol provisions. And within those provisions, there's language that says that it is unlawful to be, if you're served with an injunction, to be in the presence of narcotics, in the presence of alcohol. And again, as a result of a change in the case law, that language within those 2 provisions are no longer being enforced. And so again, there was a publication, both the newspaper in English and Spanish, posters throughout the safety zone and the communities that are affected, and mailings to the individuals that L.A.P.E. identified as having been served, informing them that those 2, and again the curfew provision, were not going to be enforced. And so those are the provisions that, as a result of changes in the case law, are no longer being enforced, and the individuals have been informed of that fact. There's a 4th provision, it's the obey all laws provision, because we all have to obey all laws, and so there's really no need to have that provision in the injunctions enforced, because that's something we have to do anyway. And also, we want to make sure that the injunction, which is a tool like any other penal code section that we have, is used judiciously. And so, the one thing I will say is injunction from where they started and where they are today, the case law has evolved, the use has evolved, and the manner in which the tool is used is different today than it was many years ago. And so that goes to the provisions that are not currently being enforced. And just to let everyone here know, that information that I'm sharing with you is contained in the L.A.P.E. operations order. So it's not just my saying it, it's just not my telling you what the changes in the case law are. It is something that the L.A.P.E. officers who are responsible for enforcing injunctions using this tool are aware of those provisions and know that those today, yesterday, and when the change from the case law happened, are non-starters. Now, saying that doesn't mean that all the other provisions within the orders are not enforceable. It's just those 4 provisions are not being enforced. And that's not to say that in the future, if there were a future gang injunction, and I'm not saying in this community, but just generally speaking, that those particular areas that are currently not being enforced couldn't be written in such a way, for example, the curfew provision, that would stand constitutional scrutiny. But because we're dealing with older injunctions and older language, we're just not enforcing those provisions.
Thank you. If you have any questions, please write them down, because we're going to go through the panel. We're going to have some questions and answers, and then we're going to open it up to the community. in a little while. But before I ask another question, I want to make sure that we all understand that some of this information we don't hear, we may not like. But we asking that everybody respect this process. We know that some of this stuff we feel like folks have been put on the injunction, folks have been arrested, folks feel like this stuff has been wrong to not only them but family members, but we're here to try to come up with creative solutions. So like I said, you may not like some of this, but with all due respect, let's keep the tone respectful so that we pay honor to our elders in the room, but most importantly, those who spend their time here. Josh, what does it look like? You've worked with Anthony. He is from this community. What did that look like to have Anthony removed off of the injunction? Can you talk about that process?
Yeah, so Anthony is, and I think Arturo would agree with me, an easy case. The city attorney's office has for a long time had a policy that which somebody would have a rebuttable presumption of removal from an injunction, which just means that we assume that they should not be on the injunction when they're, and correct me if I get this wrong, but 3 years of no supervised release, no probation, no parole, no arrests, no charges, no convictions, no bad contact from law enforcement. And Anthony was a pretty straightforward case. It had been well over 5-6 years actually when we started filing. He's working full time and has a family. But I think what was striking, and Arturo and I have talked about this, is there is, and I think there was a lot of people who began applying when these notifications went out. There's a challenge around what kind of person power it takes to process this, and it took a while for Anthony to get off of the injunction. And I think from the perspective of Anthony, and I guess Anthony, I spoke to him and he said it was okay just to sort of share his perspective. He continued to be in fear of enforcement for a period of over a year while he was waiting to hear. And I think that's a little bit the tension that I have felt working with individuals who have made changes in their lives and who are working full-time and who have not had negative contact with law enforcement. And that was certainly something that Anthony felt. I'll also share with you, though, that when he heard the news, he was very grateful to go through the process. And when he heard the news, he was both excited for himself and also ready and wanting to be an example for others in this community and other communities that it can't happen. But you know, he could have been one of the individuals who was arrested for an injunction violation for being in the wrong place at the wrong time, theoretically. And we hope, though, that law enforcement is aware of that Anthony has not had negative law enforcement contact and that there's discretion there. But he did operate in fear of that type of thing while he was going through the process, which I think is understandable. I don't think that anybody on the panel would necessarily not understand that. I'm not speaking for everyone on the panel, but it was understandable for me to hear that from Anthony.
Thank you. Thank you. I have a question for you, Captain H.E.L.P.E.R. We've had some pretty candid conversations about what's going on in the community, what's happening at Oakwood, and some of the perspectives and some of the complaints that you said you've been receiving. What has forced your division to increase the suppression tactics in the Pacific area?
So first, Melvin, that's a very complex question. The reason why the community hadn't seen the use of injunction is because we had a new unit. There's new officers that transfer in and transfer out. And in order for us to use the injunction or to actually legally stop someone and enforce it, the officer has to be trained, including training from the city attorney's office. So we're in a position where we had to train our officers up on that. I can share some statistics with you, and Arturo has the injunction zone, which we'll share with all of you. But I want you to know that if you break it down just to Oakwood Park, year to date, over 232 calls for service. Those calls for service include disturbance of a group, minor radio, disturbance of a fight, shots fired, assault with a deadly weapon, prowler, narcotics activity, intoxicated group, burglary calls, battery calls, screaming woman calls, persons with mental illness, indecent exposure, robbery, aggressive animals, burglary from motor vehicle, children left alone, traffic related, and vandalism. your question, for those reasons, we're required to spend time and properly enforce concerns that come from the community. We're responding to other calls coming from the community. Maybe some of you who aren't in this room who have generated those calls for service. It's my responsibility to respond to the community and address those things. And answer your question, part of the reason why we feel there might be more enforcement or more presence is in response to what I just cited to you.
Tommy, as a community member, what are some of your concerns, or what are you hearing from community members about the increased enforcement? And also some of these numbers that the captain has broke down about what's happening in the Pacific Division.
First of all, I think my concern is the validity of the calls. I'm sure there's an escalated amount of calls with individuals that don't look like you are congregating at the end of the park and you're not used to it. Or you are used to it and you are not used to it by just moving into this community. I do have a concern about the validity of the calls. There are some of those calls that we can rectify. The indecent exposure calls, we probably need to put a bathroom on the other end of the park. It's a long way down here when somebody has to use the restroom. I'm not validating it, I'm just saying what we need in the community. We're talking about solutions as opposed to what the problem is. We understand the problems, we need to work on solutions. And so I have some, my concerns is that how many of the individuals that are on the gang injunction actually receive notification of the changes? Because I did hear the district attorney or the city attorney say that individuals were notified, and it would behoove me to know how many more individuals from this community were notified of the changes, because those are extremely drastic changes that any individual that's on the injunction should be notified of. Would you know that?
In response to the question, every individual that L.E.P.E. identified as having been served, their last known address, and using the DMV database to find addresses was used, and the notification was mailed to the last known available address, 1. 2, the same notification was literally poster sized and tacked up around the community. It happened twice that we did it, one, as I mentioned before, just for the curfew, and then for the other 4 provisions. And then the third way of notification was in print through newspapers of wide publication, the Times in English and Albino in Spanish, and those were the manners of notification that we used to get the word out to everybody.
So one additional question. One question. Can you give us some clarity on what it takes for a person? I live in Venice. I'm driving through the community. I'm here every day, something's happening with me, you see me. Can you talk about the process on what it takes for me to be put on the gang injunction? What does that look like?
Well, when we're talking about being put on the gang injunction, it's more we're talking about being served with the gang injunction. So after the city attorney or prosecutorial agency goes to civil court, presents the evidence, the court finds by clear and convincing evidence that there's enough activity that demonstrates the public nuisance, that the tool of gang injunction is appropriate, and the court signs the order, then that order that we refer to as a permanent gang injunction order, then the officers have that tool. Now, service today, this is how it would work. We don't leave it to the officer's discretion to simply say, these are the people we're going to serve. And this is where the evolution of injunctions has occurred. Today, what would end up happening is, and this is just in the city of LA, this isn't as to any other prosecutorial agencies or any other jurisdictions. What we do in LA is we require the LAPD to then present our prosecutors with the evidence they have that an individual is an active member of a particular gang. So we make them front load the information. We want to see it. And one of the reasons we want to see it is because it is a tool and we want to make sure it's used fairly. But if we're going to be charged to proving a violation of the law based on this tool in court, we have to know that who we have before us is in fact a member of the gang that's enjoined. And so what ends up happening is LAPD will present our assigned prosecutors that evidence, the law enforcement contacts, the arrests, etc. that demonstrate whether or not the individual is an active gang member. If we're presented with insufficient information, then we won't approve service. If we are presented with sufficient information that we believe that if there was a violation of gang injunction, we can prove it in criminal court, then we will approve service. And so it creates a level of checks and balances in terms of who gets served. And then once we say yes, there's approval for service, then the officers can then personally serve the individual with a copy of the injunction. And once the person is served with the injunction, they are then subject to the terms of the injunction, and there will be provisions in the injunction that say these are the things you can and cannot do within the safety zone. The safety zone is that defined area where the injunction applies. And so if a person is within the safety zone, they can't do certain things. And while injunctions, many of them are similar because of the activity of gangs, many of them are tailored to the particular activity of certain gangs, and so they don't all read the same. And one of the things that we do when we train the officers is we insist that they read each injunction because they are slightly different, that they understand the mechanics of the injunction, that they understand what we need to prosecute a case in court, and we also train them in terms of what it is we need to see if they want to serve someone with an injunction, the level of evidence that we're looking for in order to approve service. And so that's how someone would quote-unquote get on an injunction, which is actually being served with an injunction. The other part of that is the removal petition process that Josh was talking about a little bit. So if there's an individual who's been served with a gang injunction who believes they shouldn't have been served, or they've left the lifestyle and they want to move on and they don't want to be subject to enforcement, the removal petition is a non-judicial process whereby an individual, and again, this is in the city of LA in our prosecutor's office, and it's other agencies have developed similar petitions, but in the city of LA, what we've done is it's a non-judicial process trying to make it as easy as we can on the person, where they fill out our form, it basically asks about education, employment, tell us a little bit about yourself. They simply have to say, look, I just want off, they don't have to tell us anything. It's also not an opportunity for us to gather intelligence, to get any information about crimes, about their crimes, anybody else's crimes. It's just about their personal circumstances. Some people actually tell us, look, I was younger, this was a situation, this is how I got involved with gangs, and now I'm no longer involved in gangs, and I want to move on with my life, and I want to get this injunction thing off of my back. Other people simply say, hey, I want out. And then that may be all that they want to say, and that's okay. And then what ends up happening is we check out everything that we're provided. We also reach out to our law enforcement partners to find out what information, if any, exists of active gang membership. What's this individual doing? What's law enforcement have on them? And we then gather all that information. We give the person an opportunity to interview with someone outside our prosecution unit so that there's no bias. It's a simple interview. So if the person has anything additional they want to share, they can. And then all that information is packaged together and provided to someone in the City Attorney's Administration, again, outside our gang prosecution unit, who can just objectively review everything and make a determination. If a person is approved from removal from enforcement, which has happened, they get a letter notifying them of that. LAPD, from the deputy chief, the captain of the particular division that enforces that injunction, and the supervisor of that gang enforcement detail, they're also provided that information. That way everybody knows that this particular individual is no longer subject to enforcement, so that we can avoid the concern of getting picked up because they still believe they're subject to the injunction when in fact they don't. And just like a wrong person certificate in court, we always recommend that people keep a copy of that letter on them so that if they happen to run into an officer who just doesn't know, that they can show that letter to avoid any errors from occurring, because everyone should know. For those individuals who are not successful in getting removed from enforcement, the reason for their not being removed is explained, and they're invited to reapply once whatever it is cleared up. And yes, we've had people who have just suffered a conviction for a gang-related offense who apply and petition, and they'll be explained that once that's cleared up, once they're on probation, to reapply. Because we look at it on a case-by-case basis, and each individual is different, and we look at their particular circumstances. We've had circumstances where people applied because they thought they were subject to it because they lived in that particular community, and it turns out that we've had no record that they were ever served, and they get a letter that states that as well. We've also gotten some petitions that are actually for other jurisdictions, and then we make sure to connect the individual with those jurisdictions to make sure that their requests are heard by those other prosecutorial agencies or law enforcement agencies that are charged with enforcing those particular injunctions. And so That's kind of an explanation of how someone gets served and gets put on injunction. It's an explanation on how an individual can be considered to be removed from an injunction. And again, the idea is it is a tool. It is a tool to deal with the public nuisance created by gangs. It is something that we want used correctly and judiciously, but we also realize that people are individuals and individuals do change. And because individuals do change, we have to give them an opportunity to let us know that so that we can remove from enforcement. And it was a community meeting just like this, because the removal petition came out of meetings with the Watts Gang Task Force. And we were hearing, you know, it's a life sentence, there's no way to get off, what do we do? You know, people do change. And in response to that, we painstakingly developed this petition process. Albeit, you know, it's a lengthy process, and you know, people will have their thumbs up, thumbs down criticisms about the process. But at least it's a process, and it puts us somewhere new where we weren't many years ago, which is to give these individuals who are served this opportunity. And again, it's an opportunity that even if not successful, they're re-invited to reapply when they address that particular issue. Another category of individuals that we've come across are those individuals that are right there on the cusp, where we're like, you know, what we really need them to do is one or two things, and we've actually held off making decisions and told the individual, look, if you do this one or two things and just report back to us on your progress on this, you know, it's looking good. And we call them decision deferred. And we've had individuals who've actually done that, come back, demonstrated whatever it is that the reviewing authority wanted and accomplished, and then they've been successful in getting removed from enforcement. And then unfortunately, you know, individuals are people, and people have their strengths and weaknesses, and one of the weaknesses that sometimes people we suffer is with follow through. And sometimes people don't provide enough information, we reach out, we try to get additional information, and kind of the process, you know, kind of stutters and stops because we lose contact with the person, or the person doesn't get additional information that we're asking for. All that said, that doesn't preclude the person from reapplying. And so, you know, it's a spectrum from service, enforcement, people on the injunction, but here's a way of getting off the injunction, and we've tried our best to make it user-friendly as possible with our injunctions. Some of our injunctions have what's called an opt-out provision where individuals could actually go to civil court, and so think about it, you go to court, it's a civil proceeding, notice motions, etc. But we even thought, hey, let's try to make it even easier than that. And that's why we developed the petition process. So that kind of gives you the full spectrum of what we're doing with injunctions, from service, how someone gets served with an injunction, to how someone can get off an injunction.
Thank you. One final question from me, Catherine. Can you give us your perspective of this injunction and some of the work that you've done in Orange County around the injunction?
Sure. I'll start with the work in Orange County because it's a little bit different, and I'll talk about my perspective on this injunction in a second. The work I've done in Orange County has been a little bit different because the injunctions in Orange County are written a little bit differently. They do have different provisions in them. They restrict individuals from doing different things. The service of people who are placed on the injunction is a little bit different. And most of what I've been doing in Orange County has been working on new injunctions that are not yet fully approved by the courts. The way, and the city attorney talked about this somewhat, and some of you might already understand that usually the way gang injunctions work is it's a lawsuit that the city files against the gang. It's not usually against individuals. And that means that when the city gets the court order against the gang, they can decide who are members of the gang that should be subject to the court order. In Orange County, what the district attorney has been doing is naming in their lawsuits only the gang and not any individual members, so that nobody actually shows up to court to contest the injunction, whether it should be in place at all. And we've been largely contesting whether that is a constitutionally legitimate process to serve just the gang and not allow any individuals to participate in the initial lawsuit getting the court order. We've also been involved with some individuals who are on what the Orange County DA calls an enforcement list, that aren't formally part of the lawsuit, but who are going through individualized hearings to determine if they're an active participant in the gang, and we're representing one of those individuals. The reason why we're doing that, and part of my great interest in this particular injunction is that a couple of years ago, the ACLU won a big case called Vasquez in the Ninth Circuit Federal Court. And one of the things, among others, that the Vasquez decision said was that due process of law requires that individuals who are alleged to be gang members, active participants in gangs, should have an individual hearing before they're subjected to the injunction because, first of all, determining who's an active participant in a gang can be a tricky thing. It's very fact-intensive, it's very individual, it shouldn't be a one-sided process where the police present all of their information. They say, oh, this person's been arrested X number of times, we see them hanging out with people that we think are gang members, we know that they've been picked up once or twice for drugs, and therefore they should be on the injunction. And given that that is usually a one-sided process, and given that the determination of whether somebody is an active participant in a gang is so fact-intensive, the court said that determination needed to be made on an individual basis before the person should be subjected to gang prevention. Now, that was in 2013. The bulk of injunctions in LA came into effect well before that, which means that nobody in LA who was put on a gang injunction, certainly before that time, outside of the petition for removal process, has had any kind of an individualized hearing about whether they were an active participant in the gang at the time they were put on the injunction, and certainly not since. My interest in this particular injunction is in part because it's such an old one. It was put in place, I think, in 2000. The community has changed a lot in the last 15 years. And what was required to get a gang injunction is proof that the gang is creating a public nuisance enough that individuals' personal liberty can be curtailed beyond just what's already illegal, but curtailing activity that is ordinarily legal. The idea is that you can do that to individuals only because the gang itself is such a big nuisance in the community. Now, regardless of whether that was the case 15 years ago, I think it begs the question of whether it's still justified now.
Thank you. So we're going to open up the questions for the group in about 10 minutes. Stan has a few questions for the panel, and then we'll open up. Once we open up for questions for the community, we're going to ask you to line up so that we can make sure that everybody gets their point across.